Hello everyone, this is Preet Verma and this is video of subject Legal Studies, class 12th, Unit 6, that is Legal Services, chapter Lok Adalat. So Lok Adalat, as we already discussed in our previous chapter, that it is People's Court which provides the dispute resolution services free of cost. The award of Lok Adalat is binding upon the parties and it cannot be appealed. So every state authority or district authority or the Supreme Court Legal Services Committee or every High Court Legal Services Committee, or as the case may be, Taluk Legal Services Committees may organize Lok Adalat at such intervals and places and for exercising such jurisdiction and for such areas as it thinks fit. A case may be referred to Lok Adalat when the parties thereof agree or one of the parties thereof makes an application to the court for referring the case to the Lok Adalat for settlement. Now, powers and functions of Lok Adalat. The Lok Adalat shall, for the purpose of holding any determination under this Act, have the same powers as are vested in a civil court under the Code of Civil Procedure 1908, 5 of 1908, while trying a suit in respect of the following matters, namely: first, the summoning and enforcing the attendance of any witness and examining him on oath; then the discovery and production of any document; the reception of evidence on affidavits; the requisitioning of any public record or document or copy of such record or document from any court or office, and such other matters as may be prescribed. Now let's discuss the Legal Services Authorities Amendment Act 2012. Over a period in time, by increasing load and judiciary and other related issues, made the Parliament to realize that litigation-oriented legal services cannot bring out desired result. Therefore, for encouraging pre-litigation legal services, especially in public utility service, the Parliament has made certain amendments in Legal Services Authorities Act by passing an act known as the Legal Services Authorities Amendment Act 2002. The purpose of the amendment is to bring out certain changes in the Legal Services Act 1987, hereinafter referred to as the Principal Act, especially for the establishment of permanent Lok Adalats to settle disputes concerning public utility services at pre-litigation stage. Chapter 6A provides certain provisions dealing with pre-litigation conciliation and settlement pertaining to public utility services. Section 22A provides that in this chapter and to the purpose of section 22 and 23, unless the context otherwise requires, permanent Lok Adalat means a permanent Lok Adalat established under the subsection 1 of section 22B. Public utility services means any transport service for the carriage of passengers, of goods by air, road or water, or postal, telegraph or telephone service, or supply of power, light or water to the public by any establishment or system of public conservancy or sanitation, or service in hospital or dispensary and insurance service. It also includes any service which the central government or the state government, as the case may be, may in the public interest by notifications declare to be a public utility service. Now let's discuss legal aid in context of social justice and human rights. So there are millions of people who are denied human rights only because they cannot afford the cost required for the enforcement of their rights. Merely to talk about human rights from an elitist platform is not sufficient. In order to do social justice to them and to make human rights meaningful, legal aid becomes essential. The human rights which cannot be enforced due to poverty are meaningless and worthless. A right to access to justice is sine qua non for social justice. The access to justice itself is one of the most basic human rights, and without it, the realization of many other human rights may become difficult. Indeed, the right to access to justice or legal aid is evolved by judicial creativity for the benevolence of poor persons. Now, neither is it possible nor is it proper to isolate the right of legal aid from range of human rights. The reason is obvious. Mere declaration and passing of resolutions about human rights are not enough. The guarantee for the enforcement of these rights is equally essential. Hence, it will not be incorrect to say that right to legal aid stands first in this piece of human rights. Human rights are merely pious declaration without legal aid. They become lucrative only when they are enforced. The right to legal aid enables accomplishment of these human rights and makes them worthwhile for the poor masses in the world. However, another sheer fact is, in today's world, the legal system of most of the countries are very expensive. Justice is not given but rather sold. The consumers of justice have to pay the council for representing them, bear expenditure for court fees, and also other contingent charges. Indeed, the poverty is a big obstacle in the way of getting justice, and due to this reason, the poor becomes the sufferer of social injustice. Legal aid indeed is an integral part of human rights and it requires urgent considerations. Otherwise, there is an apprehension that someday the patience of the poor may be exhausted and that will endanger the world peace. So that is all for today. See you guys in the next video. Bye bye.